As I wasn't given a chance to conclude the last paragraph of my presentation to Parliament today, I'm going to start again so that everybody out there who this concerns can listen to the whole presentation. Honourable members of the committee, we have previously submitted comments and given oral submissions on 2 occasions. We refer to questions asked previously which remain unanswered. Where is the credible scientific and academic evidence upon which the bill is based, or are we to expect the passing of a bill through Parliament to proceed without such evidence? Who is going to come and count my dagga plants? Will the South African Police Service be charged with counting and measuring the plants and the THC levels of an estimated 20 million South African cannabis users, cultivators and traders in order that they can enact the irrational and unconstitutional criminal penalties suggested in this bill? The word decriminalization is often used to describe cannabis in South Africa post the 2018 Constitutional Court judgment. This is a highly inaccurate, and this bill shows no signs of decriminalization for cannabis users, cultivators and traders in South Africa. Criminals are people who harm other people. It is 1,056 days since my partner Julian was shot dead at 2 a.m. in our bed. The person who shot him is a criminal, not me and my dagga plants. It is also criminal that the SAPS has never investigated his murder. There is nothing I can do about that. I am powerless. But there is something that I can do about the threat of criminalization hanging over our heads of our South African cannabis community, and I will never give up fighting for our rights to evidence-based laws and regulations. We would like to bring to the committee's attention an email sent yesterday by the head of our legal team, Paul Michael Keichel of Cullinan and Associates, explaining the exact legal parameters of plant counting and the law. I trust that the committee and the numerous legal minds before me take note of the facts contained therein. If these legal facts are not taken into account, civil society will be forced to present these facts in court. This will be at our personal expense, but the government can rest easy that all expenses related to another court challenge will also be borne by civil society, us, the taxpayers. That is ironic and a travesty of justice, as we all gather here and say the same thing over and over again. Fields of Green for All would like the committee to note that of the 19 submissions presented over these 2 days, excluding us, 16 organizations, companies and individuals are directly aligned with Fields of Green for All. Our aims, objectives and values are the same, and we all support each other. Our objections to this bill should be seen as one voice, and we are in a clear majority in this room. We would also like the committee to note the presence of Doctors for Life, the only prohibitionist group represented here. In 2017, Doctors for Life in the state were the reason that our case was rendered part heard in the Pretoria High Court. Our opposition spent 3 full days arguing against the live streaming of the trial. We won that live streaming case in the Supreme Court of Appeal with a costs order. To date, neither of our attorneys or the sheriff of the court has been able to locate Doctors for Life in order to effect that costs order and reclaim our expenses. The state has also not paid that costs order. It was with great surprise that we noted the presence of Doctors for Life here, as they remain in contempt of court of this matter. Fields of Green for All spent 6 years researching, compiling and publishing our manifesto. This guiding document was introduced to this committee during our very first presentation here. Yesterday, the committee was asked, well, what are your solutions? Here are the solutions. This committee has had 5 years to come up with credible evidence-based solutions, but has ignored our hard work. All 15 entities mentioned above, plus many more organizations, companies and individuals, both here and in South Africa and around the world, support this document. Fields of Green for All has special consultative status at the United Nations Economic and Social Council. We are considered leaders in our field and have presented our position to communities in every corner of our country and further afield, from Nigeria to Montreal, from New York to Vienna. Next week, I will be speaking at the African Futures Conference in Cologne, Germany, on the invitation of the university there and the universities of Bristol and Cape Town. Internationally, our voice is heard, but our government ignores the content of our submissions and the submissions of our colleagues over the last 2 rounds of these hearings. Fields of Green for All notes that comments are only invited for sections of the draft bill pertaining to industrial cannabis. Why is the subject of the use, cultivation and trade in industrial cannabis included in a cannabis for private purposes bill? But there's no regard given to the personal and private use of industrial cannabis. Where are the protections for or uses for our unique, diverse and climatically appropriate land-race cannabis cultivars that have been the cornerstone of rural cannabis cultivation in South Africa for centuries? This is given the threat of imported hemp varieties, pollen drift and unscientific THC thresholds. I am not going to repeat all the salient facts about industrial cannabis that have already been addressed by my colleagues, save to repeat that experience the world over has shown that industrial cannabis laws and policies that look more like drug laws and policies fail in all aspects. Fields of Green for All's position on the Cannabis for Private Purposes Bill remains unchanged. Within our far-reaching constituency and including our fellow civil society organizations engaged in intensive work around the re-legalization of cannabis in South Africa, we have not come across one credible individual, organization, academic institution, or expert who is of the opinion that this bill will pass constitutional muster. Criminal offences continue to make up a large part of the draft bill. Scientific evidence of harm that would justify such harsh penalties is just not there. The continued laborious breaking up of the definitions of cannabis, quantities of cannabis, cannabis and privacy, cannabis for communal, traditional, religious use and cultivation, etc., is a symbol of a lack of awareness on the part of the legislatures of the dire need to reform the relationship between cannabis and law enforcement. That is, arrests, incarceration, labor issues, family law matters. We know, and this was mentioned by our attorney and representatives of the Mzimvubu Farmers Support Network, Ricky Stone, yesterday, that there is work being done on all purposes, cannabis bills and legislations and master plans, in line with the promises made by our president in numerous State of the Nation addresses. This committee has only itself to blame for wasting 5 years on an unconstitutional bill. The upcoming elections cannot be used for pushing this bill through and forcing us back to court. Further to the comments yesterday around cannabis in the workplace and cannabis in driving, we would like the committee to note very precisely that cannabis is stored in the fat cells of the body for approximately 30 days. Saliva tests that indicate impairment, either at work or at the roadsides, are the only accurate way. Presence of cannabis detected in a urine test or a blood test does not indicate impairment, does not indicate that I am high at work or that I am high driving. Fields of Green for All is currently supporting a case in the Labour Court in this regard. We have a constitutional right to the private use and cultivation of cannabis within private spaces, yet we are also supporting the Hayes Club court challenge, and we have been appointed as amicus curiae, friend of the court, in this case. In terms of the 2018 judgment, we should be allowed to operate dacha private clubs, of which there are an estimate 400 already established in our country. But our government fails to see this as a harm reduction measure, which has been tried and tested internationally for the past 20 years. In March, I attended a study tour in Spain, which included 30 participants from 11 different countries. International drug policy advocates recognize that private clubs are a solution to the human rights violations associated with cannabis prohibition, but South Africa still wants to lock us up in cages. This committee knows well the observations and astute opinions of the Honourable Judge Cameron. Are we going to continue to fill our police holding cells and prisons with peaceful, non-violent cannabis offenders, or are we going to get the sector off the ground in a human rights, constitutional, and evidence-based manner? If you are reckless and uninformed as to the science of cannabis and the perceived harms of use, cultivation and trade, then civil society will be left with no choice but to return to court for the trial of the plant too. I am personally the only plaintiff still alive to fight this case, but I am comforted and supported by millions of cannabis users, cultivators and traders in South Africa and around the world. Centuries of use, cultivation and trade have failed to produce evidence of the harms of cannabis per se, only the harms of prohibition. Thank you for this opportunity to present these same facts for the third time. We all trust that the committee is taking note this time around. We will not give up the fight until we see fields of green for all South Africans, all Africans, and all citizens of the world. I thank you.